Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall and my co-host today is Alicia Downey. Hello, Alicia.
Hello, Matthew. Nice to be here.
Today's episode is, what are the risks of a minority shareholding? The European Commission's decision in Delivery Hero Glovo. We'll be discussing the Commission's June 2025 decision in which it fined those two online food delivery companies for cartel behaviour in the EU. The particularly interesting feature of the case is that the behaviour took place while Delivery Hero held a minority, non-controlling stake in Glovo, plus a board seat. Our guest today is Peter Camesasca. Peter is a Brussels-based competition lawyer with his own firm. He has experience in all aspects of EU competition law, including cartel and abuse of dominance cases, merger and JV notifications, investigations, and global antitrust litigation and monopolization issues. Hello, Peter, and welcome to the show.
Hello, Matthew. Hello, Alicia. It's very nice to be on the show. I'm glad to be part of this program. Thank you for that opportunity.
Well, thank you for joining. Just with a bit of law to set the scene, under EU competition law, unless they can be considered as forming part of a single economic entity, or in other words, a group, companies that are actual or potential competitors must operate independently or risk infringing the law. Single economic entity is based on the concept of decisive influence. So, where there is a minority shareholding held by one competitor in another, unless the shareholder has decisive influence over the other company and they are therefore a single economic entity, they will be considered independent competitors and the shareholding does not change that. So Peter, against that background, could you give us a bit more detail as an introduction about the Delivery Hero Glovo case and outline what the Commission found?
I'll be glad to do that, Matthew. So to be clear up front, there is no published decision yet, right? So what we have at this point is, on the one hand, the press release, and on the other hand, the so-called stated remarks, which the Competition Commissioner, Ms. Ribera, issued on the same day of issuance of the decision. And that is typically a sign that it's an important case. And in fact, in this particular case, these stated remarks are at least as interesting as the press release. In fact, it gives a bit more coloring. You already set the scene very well, Matthew. And I think for those of our listeners who only have 5 minutes, listen to Matthew's introduction and you have the core of the case and why it's important. I will recap it because I think it really will lead throughout our podcast. Two reasons. The first reason is this decision deals with no-poach arrangements, the arrangements not to hire or actively approach each other's employees. And the second reason is, as you already directed us to as well, the use of minority stakes to remove competitive constraints. These two aspects of Delivery Hero, and then I'll go into the case in a minute, will require, in my professional opinion, the amending or at least the fine-tuning of compliance programs as we know them when it comes to exchanging sensitive information during and after acquiring a minority stake. So, when you think clean team rules, when you think about, putting together a minority stake, who should be sitting on the board, what can be discussed at the board, special step-out reporting provisions, and so forth, those are all essential items to look at following this decision. Now let's look at the case itself. It's a 329 million fining decision that is, if you were to ask me for a one-line summary, 4 very expensive years to becoming one company. Because those 4 years is what it took Delivery Hero to gain the slow path of control over its competitor Glovo, during which, unfortunately, a couple of things went wrong compliance-wise. Now, these companies, as you already identified them, are both active in the online food delivery sector. Delivery Hero is by origin German, Glovo is Spanish. Now, how did this case then come about? Well, we go back in time. We're now pre-Corona. Somehow we seem to, think in times of before or after Corona. So before Corona, July 2018, Delivery Hero takes a 15% non-controlling stake in Glovo. And then progressively over the years, that increases through subsequent investments, and eventually the two companies come to a full merger, as in a full acquisition, in 2022, which was cleared by the Spanish National Competition Agency, the CNMC. I'm going to do horrible things to the pronunciation, but it's the Comisión Nacional de los Mercados y la Competencia. And that was in February 22. And that is when Delivery Hero finally acquires full control over Glovo, so nearly 4 years after the initial stake. So far, so good. Just another transaction, right? The problem is that the Commission found that by the time Delivery Hero acquired sole control in July 22, the two companies had already removed progressively the competitive constraints between them. So they weren't one, or they weren't under one hat yet, but instead, to quote from the press release, they had, quote unquote, replaced competition with multi-layered anti-competitive coordination. Now, what was the Commission referring to? 3 points in the press release. First, as I mentioned, not to poach each other's employees. Second, to exchange commercially sensitive information. And then the Commission adds as a third layer, but you could subsume that into the second one, to allocate geographic markets. Now, recall the timeline, February 22, clearance in Spain, good to go. In June 22, so a mere 3-4 months later, the first of 2 Commission dawn raids start at both Delivery Hero and at Glovo. Second one follows in November 23, so another year later. Then there are 2 years of investigation. We're now well beyond Corona time. There's a statement of objections for our US listeners. That's like our European version of the indictment, if you will. And that's in July 24. And then now a couple of, actually in June, so a small month ago, there's the fining decision through settlement, which means that Delivery Hero pays $223 million and Glovo $106 million. Not a lot of detail in the press release about how that fine was calculated, but if you simply look at the absolute numbers and you think about the turnover of these companies, it's clear that this is an infringement which the Commission believes is very grave, because gravity, as we know, is one of the factors that contributes to the number of the fine. One side note, and then I think we've covered the decision. If you read the press release, you'll see that the Commission takes great care to identify this decision as an own initiative inquiry. Right? So we hear a lot about how amnesty and how leniency is really the driver of anti-cartel enforcement. But here, the Commission makes a point of saying, well, we got some information from an unnamed national competition agency. We had some use of our so-called anonymous whistleblower tool, but, it's our investigations. We kicked it off. There wasn't an amnesty applicant. And really to say, we are one of those leading, path-breaking anti-cartel enforcement agencies. Not that we needed reminding of that, but it also shows that, investigations can and will be started by our antitrust regulators.
Well, thank you for the excellent summary. Let's turn first then to the general implications of the Commission's approach to the minority shareholding issue. Now, from what's been published so far, it does seem as if the Commission's acknowledging that merely owning a minority stake in a competitor is not itself illegal. Same here in the United States. But here, the companies had somehow formed a channel to communicate and exchange confidential and competitively sensitive information, to influence decisions less than independently, and that allowed Delivery Hero and Glovo to essentially allocate markets. Do you think that the decision of the Commission puts the use of minority stakes as a means for investment in some doubt within the EU? Is it the case that it's still basically fine, but this case may be a good reminder to competitors involved in cross-shareholdings and JVs and to investors in multiple competitors that they need to operate appropriately?
I think, as you were leading in this question, if you put the stated remarks of the commissioner next to you, you'll see that she actually answers the question in many ways. She says, owning a stake in a competitor is not illegal in itself. Well, thank you, Commissioner. That's very helpful. And then she goes on to clarify that the problem only emerges when that minority stake is, quote unquote, used to gain inside information and influence decisions in ways that can harm competition. Well, so what does that mean? I think the simple read is, short of two competitors becoming one company, whatever that means under EU competition law, right? But becoming one company and instead remaining independent market players. Remember how in July 2018, we're talking about a 15% stake, right? It means that the EU's far-reaching by-object interpretation of information exchange remains in full force. We've had this standard in Europe, I think, since the smart card chips cartel decision in 2009, but it still remains important for our non-EU listeners to really be clear that in Europe, we don't need an agreement. We don't need a fix to have a cartel finding. As long as, or if, rather, companies exchange sensitive, forward-looking information that's on par in the EU with actually fixing prices, quota, capacities, costs, tariffs, customers, whatever you can fix, right? Now, the harder read is, how or when did Delivery Hero and Glovo cross the thin red line? And I know we'll be talking about that some more later in our podcast here. But let's go back to the stated remarks, which are actually quite informative in this case. And the commissioner says that these two companies exchanged sensitive information on, quote unquote, beyond what was needed for a corporate investor to protect, a different place of her remarks, she says, to monitor a financial investment decision. Okay, so what do we learn about that beyond? Where did it go too far to protect your investment as a minority stakeholder? In another way of putting it, this premature management creep, if you want, where did it go too far? So if you take the press release, take the stated remarks, you learn that Delivery Hero and Glovo shared, quote unquote, strategy documents. And they also held, quote unquote, meetings to share knowledge, including on current or future commercial strategies and new offers. Recall how I mentioned that the EU has three strands in this decision: no poach, information exchange, and market allocation. But I think it's a good point to look at that market allocation aspect as well here, because in the decision, systematically, these aspects emerge due to the ability the minority stake gave Delivery Hero to, quote unquote, convince Glovo to share markets in two ways. One, directly by using or threatening to use its approval rights over specific decisions, and two, indirectly by influencing other Glovo shareholders, end of quote. So effectively, Delivery Hero and Glovo discussed and agreed which of them would enter new national markets where neither had a presence yet, and they also refrained from entering markets where the other was already present. Now, where do we place the thin red line then? I think it's when minority stakes start acting as facilitators to a cartel. And I think this is really important when this is food delivery, right? But when you look at this a bit broader, think about the startup scene, which is so driven by minority stake investments. Think about IoT investments. Think about financial services, where comparatively large investments, non-controlling stakes, are often secured exactly through board positions and the like, which was exactly what happened in Delivery Hero. I think this Delivery Hero precedent is clear. As long as there's no sole control achieved, as long as it's just a minority stake, companies remain independent. And then you need to avoid what I call that premature management creep, aligning, in this case, labor law approaches, commercial positionings.
Peter, it's interesting, before we move on to information exchange in a bit more detail, perhaps, just to comment on the allocation of geographic markets elements. It was quite remarkable, I thought, in the comments from the commissioner that the parties even agreed to remove their geographic overlaps by selling each other their businesses in certain markets, which seems to me a pretty remarkable piece of cartel activity that came out of this. But going back to the information exchange side, as you say, under EU law, a standalone or even one-off and one-way exchange of CSI can amount to an object or automatic infringement if uncertainty is reduced. I want to ask you a bit more about the thin red line. I mean, these are competitors. Presumably, as in a merger or an acquisition, they can, or the shareholder can obtain confidential information which is not CSI in order to monitor what it needs to look at its investment. If it's going to be obtaining necessary CSI, presumably there needs to be some kind of protection, as there would be in a normal due diligence situation. So you commented the type of information that went too far. So up to where does the thin red line go in your view? So what confidential information can they obtain that is reasonable in this scenario? And if they're going into CSI, how do they deal with that necessary CSI? How do they deal with that position?
Let's take a step back maybe and go to what's also really the core finding, that minority stakes will and should continue as a means for investment. Because, they do allow companies to collaborate strategically without triggering a full acquisition or merger. That is important. Minority stakes may also support joint R&D or the co-development of products or technology sharing. And that is particularly important in these fast-moving startup scenes, as I mentioned, IoT, biotech, automotive, financial. And I also think minority stakes allow you to do that in a commercially less risky and more flexible manner than in a merger. So securing that through a board position is important, because that also allows, for more cautious managerial decision taking. What does that mean in terms of the minority stake? There's a really interesting book. It's a bit dated. It's from 1996, and it's called The Antitrust Limit of Co-opetition. It's by two gentlemen, I think Adam Brandenburger and Barry Nailbuff. That goes into quite a bit of detail, which, incidentally now has become quite relevant again. How best to advise deal makers to put their minority stakes in place without risking, the additional cost of $329 million that Delivery Hero and Glovo now have accrued on top of their investment. So the first one is, as I mentioned, the use of strict clean team rules when negotiating. So it's really that early up level while you're still in negotiation. I think the second point I take from the Brandenburger-Nailbuff book is to install clear and upfront protocols, and ideally do that already in the SPA, in the shareholders' agreement, for the functioning of the board. The parameters that can be discussed or cannot be discussed within the remit of the minority stake. And then, because this is running a business, so inevitably there will be sensitive areas in these board discussions where it would otherwise go too far, I think I would also look at having a so-called step-out process in place when these inevitable sensitive topics come up that the minority shareholder shouldn't be aware of, so that the representative can go out. The final point I'd direct you to is the choice of individuals. Because, of course, in the end, it's the human that will be sitting on the board. And, well, who are you going to choose? A business leader, or maybe someone more from the financials? What sort of guardrails will you be providing that person with? What sort of targeted compliance training? What sort of structural firewalls will you be considering to lower the exposure? I think that's really important, because some of our jurisdictions, also in Europe, like in the US, are criminal. Not at EU level, but some of the national laws are. And so if you are a soon-to-be appointed board member in a minority stakeholding, maybe you want to feel secure and not visualize yourself in an orange jumpsuit.
So, Peter, is the idea there that the board member and, of course, other general information that may go to the shareholder does not include competitively sensitive information at all? I mean, the information will obviously be confidential, but is the idea there that CSI does not flow at all up the chain?
No, I think there I would go back to the Ribera comments. It shouldn't go too far. What do you need to protect your investment? Right? You have put money in the company. But I think here, and this is why I like to look at Delivery Hero and combine these two strands of information exchange and market allocation. The answer to your question is so well illustrated by how far these two companies went in their board meetings, telling each other, I will go into this market, but then you will not go into that market. Well, one shouldn't be doing that anyway. One shouldn't be putting no poach, for that matter, into your SPA, right? But it also goes to show and illustrate an example that has nothing to do with your minority stake.
Yeah, it's clear that those types of discussions were CSI, and were CSI which Delivery Hero did not need in order to monitor its investment. But if there is CSI that they do need, necessary CSI to monitor their investment, presumably, I think you're saying that would be okay. The question then is how that is dealt with when it goes into the board member or indeed up into the shareholding company. Is that what you're saying?
Absolutely. And that is why I think the choice of person is so important too. Because, it's one thing to say, I have a firewall and I have all these, compliance measures in place, but you cannot expect, if the board member of the minority stakeholder is a business person that is active in the same business as the target, I would like to see or maybe not see the person who's able to split his or her brain and completely disregard what he or she learned in the board meeting. So I think
it's very similar, it seems to me, to, an acquisition due diligence, right? So if there's necessary CSI, which an acquirer needs to look at for the purposes of an acquisition, you bring in non-operational people. They can look at that information, but of course they can't be involved on the operations side, and they may need to step back for a year or whatever after if the transaction doesn't close? Is that the kind of structure you'd be thinking about?
I'm totally with you there, Matthew. And I think that's also why, as I started listing the various aspects to think about, I did start with the clean team rules already when negotiating, because I think that's when you start setting the scenes. And as you say, exactly based on those same principles. And that's like a trickle down from here is we're looking at the stake and here is we're actually implementing it and running the minority stake once we've made the investment.
Absolutely. Just before we finish here, Peter, it's interesting, as you mentioned, the case looked at no poach, the first commission decision in the no poach area. It seemed to be a pretty clear no poach discussion, but one interesting issue that's I think in practice is more relevant in this area is the issue of how these no poach type discussions relate to the use of ancillary or to the ancillary restraints doctrine. Certainly, when I look at these in practice, most times it's the question: is this discussion about no poach or no solicitation ancillary to a wider arrangement and therefore fine? So maybe you can make a few comments about how that did or did not apply in this case.
I think that's a really excellent question, because the short answer is I think it would be very difficult. Exactly because in the EU, cartels are by object infringements, which is in a way our equivalent of a per se infringement in the US, which does not, to be clear, entirely disqualify the application of the ancillary restraints doctrine. It just puts the bar really, really high to make it work. So what are ancillary restraints? I'll do this very quickly for the non-EU audience. These are essentially exceptions to the application of Article 101 of the cartel enforcement rules in Europe, allowing certain restrictions if they are three cumulative reasons directly related to, one, and two, necessary for, and three, the implementation of a main transaction that in itself is not anti-competitive. There is case law that says even by-object infringements can be found to be quote-unquote mere ancillary restraints. It's Wouters from 1999. These are all court judgments. MasterCard from 12. And I think the mother of all ancillary restraints cases, Metropole Television, T11299. Here the quote is that the restriction must be directly related and necessary to the implementation of a main operation that is not in itself anti-competitive. So the ancillary restraint must not go beyond what is strictly necessary, even if the main agreement is pro-competitive or neutral. It can only be exempted if indispensable for achieving the purpose. And I think that's what makes this so very, very difficult. And I have a really hard time to imagine the EU agreeing to, well, the allocation of markets, obviously. But even, when you think about sensitive information exchanges being on par with a fix, or now these no poach arrangements, are they strictly necessary for safeguarding the minority stake investment? It's possible when you think about Ms. Vestager's speech from 2021 in maybe certain markets which are really high tech, which are really aiming at certain individuals who only have this knowledge, but nothing as broad as Delivery Hero, right?
Well, thank you, Peter. It sounds to me like this Delivery Hero Glovo decision will at least serve as a cautionary tale to those with minority shareholdings, if not an earthquake-shattering change in the law. For listeners who want to see more detail about Peter's thoughts on this case, he has written an online article that we'll post the link to on this episode webpage. The title of it is Minority Stakes as a Conduit for Cartelization and No Poach to Boot, the EU decision in Delivery Hero Glovo. So before we end our episode, we're going to transition to a couple of items that we like to do with every guest. And the first thing we'd like to do is try to get to know you a little bit better as a person. Can you tell us something interesting or unusual about yourself that is completely outside of your professional life?
Well, I'll take the fifth on whether it's interesting or unusual. But as I was growing up, so in the dark ages pre-mobile phones, I actually wanted to be an artist, which had to do a lot with, creativity and inspiration and, projecting visions into realities, vice versa.
In what medium? Visual arts?
Whatever came my way in terms of paint or that would allow color to meet its maker. But thankfully, at the latest hour, art didn't make the cut. I ended up being a lawyer. But and I know I'm slightly overstepping into, this should be only about personal, not professional. But let me develop this for you, because I think creativity and inspiration, it's of course something that we need in what we do in our job as antitrust lawyers. It's equally important, right? It's understanding the client needs or concerns, listening into what people are telling us, projecting those into the legal possibilities, constraints, coming up with, creative solutions. And I think, and this is the point I want to make, so how do I get that inspiration? Where do I get that from? And as I think, Matthew, you mentioned at the start, or what you can read in my bio, I'm German. So I'm going to introduce a German concept to our podcast. In German, there is a term which I find very difficult to translate, and it's called being music sein. So if you were to Google music sein and or DeepL it, you would get such things like being idle, having leisure. And of course, now you're all thinking, aha, he's telling us to be lazy. No, the point here is it's having time free to think, away from being, engaged in the nitty gritty, free to reflect. And over the years, I found, and that maybe is the answer to your question, things like chopping wood, things like skiing, are a perfect, for me, conduit for being music, tanking that inspiration. And the fringe benefit of these wintry activities is you'll get an open fireplace. You can zip down slopes with your family and kind of, bring the family together. And so art, back to where it all started, bridges client work, bridges to the outside of my professional life. It's like, going full circle.
Peter, I think that's great advice. I'm not sure whether you're talking about the left or the right side of the brain there with the art, but I'm sure it's one or the other. And now we have our final segment of the episode.
And now it's time for the Curious Hat.
The rules of the game could not be more simple. I'm going to ask Matthew to draw a random surprise question from the virtual hat. Are you ready, Matthew?
Yes. Peter, the question for you is, what book are you currently reading? And would you recommend it to our listeners?
I love to read. And currently, I'm reading The Empty Throne by Bernard Cornwell. To make it worse, this must be the third or the fourth time I'm reading it. It's one of a series of books that Mr. Cornwell has written. And it's in the dark ages of England, or the formation of England, where the remains of Roman civilization have encountered the Saxons and are, at the time of where these books play, are battling the incursions of the Norse and the Vikings and the Danes. And the hero of the book is Uhtred of Bebbanburg, who has been chucked out of his castle, Bebbanburg, by the evil uncle early on in his life, and then struggles through mud and bad weather and many a battle in a very interesting way, also the remains of Roman civilization. And it's such a great story. And as I am currently actually on holidays in the mountains where it's still July, but it's about 2 degrees and it's full of snow and sleet. I have a particular sympathy for Utrecht's current muddy encounters.
I love that series, and they made a great Netflix series out of it too. I highly recommend it. So thank you very much, Peter, for an excellent interview, and thank you to Matthew as well. Thank you to listeners. Tune in to next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.